Okay, thank you all for coming again, and I am going to get started with Professor Volokh's opening statement.
Thanks very much for having me here. This is a subject that I find very interesting. I'm writing an article on the subject. I'm not really fully sure what the right answer is on this, and I'd love to have this conversation help enlighten me on it. So I wanted just to start for a few minutes explaining what I think is the main problem, the main rationale that some people are offering for why platform editing decisions should be, excuse me, not editing, platform removal decisions should be regulated. I'm not sure, again, that's right, but I thought it would be helpful to explore that. And I want to start with Justice Stevens's dissent from Citizens United. Now, that's generally seen as a liberal position. It was for the four more liberal justices on the court. It was very much endorsed by many liberal commentators. Now, today, the calls for social media platform regulation are coming mostly from the right, because I think it's the right that feels that they're being restricted more by social media platforms. Although some people on the left are making the same argument, but I want to tie these arguments to Justice Stevens's arguments, because I think they're actually something that's much more kind of ought to be something much more nonpartisan than may appear in the heat of battle in any particular year. So let me quote Justice Stevens's dissent, and then briefly lay out a certain spectrum of possible regulated entities, and then I'll turn things over to Shaun. Shall we be on a first name basis?
We are.
To Shaun. Good. And then we'll have a conversation about this. Okay, so let's see, share. So here's a quote from Justice Stevens's dissent in Citizens United. Remember, Citizens United was about the question whether corporations were entitled even to speak about candidates. All that Citizens United wanted to do was publish criticisms of Hillary Clinton. But the statute barred corporations from, in certain contexts, expressing views for or against candidates for office. Justice Stevens thought that there was good reason to restrict even the speech of corporations. And here's how he articulated it. A legislature might conclude that unregulated expenditures by corporations will give them unfair influence in the electoral process and distort public debate. The concern wasn't so much about corporations restricting free speech rights of individuals, because again, there it was just a matter of corporations speaking, but the concern was of economic power being leveraged into political influence. And the argument was that there's good reason for legislatures to try to limit that. Because of the speech of corporations, the opinions of real people may be marginalized. Again, there the concern was just that there could be too much corporate speech, and as a result, individuals would find it harder to be heard. As it happens, actually, it appears that corporate speech about elections is maybe about 5–10% of all of the expenditures. So probably that was something of an overstated concern, but in principle, it might be a concern. He thought it was basis enough even to restrict corporate speech in order to maintain free competition among actors in the political arena. Corporate domination of electioneering, he also said, could generate the impressions that corporations dominate our democracy and that the government is captured by corporate interests because corporations have so much influence over elections, the argument would go. And what's more, to the extent corporations are allowed to exert undue influence in electoral races, speech of the winners of those races may also be choked, because politicians may trim their sails to the winds. May say, oh, wait a minute, I don't want to have a corporation come in and spend all this money criticizing me. Or, in social media context, I don't want the social media corporations to turn off my ability to speak to the public through them. On a variety of levels, unregulated electioneering might diminish the ability of citizens to hold accountable to the people and to serve the goal of a public debate that's uninhibited, robust, and wide open. Now, I think this is a very powerful argument. I actually don't agree with it when it comes to corporate expenditures. I think corporate free speech rights, whether it's the rights of media corporations or whether it's the rights of traditional business corporations, and you could even draw the line between those two, I think that that is free speech, and it needs to be protected, even when it may pose these potential risks to political debate, among other things, because I think restricting the speech of corporations would pose undue risks to political debate. But I think that Justice Stevens's argument, even if I don't quite buy it as to corporate speech, seems to me applies even more to corporate restrictions on individual speech. Anything he said there about the risk that General Motors, let's say, to use a formerly super powerful corporation, or other such corporations that would speak to the public and that cause bad results, I think is dwarfed by the danger that corporations might block the views of members of the public, especially when they have become so influential and so monopolies, not necessarily in any legal sense, but still as a practical sense, in their particular tremendously important niches. So that, I think, in a nutshell, is the strongest argument adapted from corporate expenditures to corporate restrictions on individual speech. The strongest argument for regulating social media platforms. Maybe it's not strong enough. Social media platforms are private companies, and there's a lot to be said for private control of private property. Regulations can have all sorts of unintended consequences. It can make the cure worse than the disease. I'm totally open to those arguments. But I do think that Justice Stevens's argument, again, as applied to social media blocking, is pretty important. Now, one way of thinking about this is also by thinking about what I call the platform spectrum. So newspapers are, of course, places where people can speak through op-eds, through letters to the editor and the like. But newspapers, not only, I think, is it proper for them to be able to block things, it's their First Amendment right to block things. There's a case on that, Miami Herald v. Tornillo. And even Justice Stevens, when he talked about how corporate expenditures are so bad, would make an exception for media expenditures, like if a newspaper spends funds to editorialize for or against the candidate. So I do think that any attempt at newspapers as common carriers that have to carry all things, that's wrong. Bookstores are another example. There are feminist bookstores, there are free market bookstores, there are Christian bookstores, and I think they're entitled to pick and choose what's on their shelves. I think Google is provider of search. I wrote this as a paper commissioned by Google, but I also endorse it as an impartial academic. Google is provider of search results, for example, has First Amendment rights. I think you can't say, well, you have to provide equal search results for all viewpoints. Among other things, that would make Google search kind of pointless. Likewise, when platforms, for example, recommend pages you might like or what's happening now, I think those are choices that they make as part of the free speech rights. On the other hand, when they come to be providers of hosting for users to reach their willing viewers, for example, I put up a page and it's there for people to come and visit if they want to, I wonder if they're more like phone companies or UPS or Federal Express, or I guess FedEx is what it calls itself now, or the post office. Now, the post office is government owned and has First Amendment obligations, but those other companies have statutory obligations comparable to the post office's First Amendment obligations. They have to carry everybody. We don't say, oh, phone companies, they should be able to block some phone number when they know it's recruiting for KKK or the Communist Party or for Antifa or something like that, right? We don't put phone companies in a position where they can use their economic power to influence political debate by shutting off phone banks for election campaigns or for ideological causes they dislike. Likewise, again, with the post office or UPS or FedEx. And that, by the way, is true not just of monopolies like landline phone companies, but of cell phone companies, which are notoriously highly competitive, and UPS and FedEx, which are not monopolies at all. So my sense, and I'll close on this, and then we'll have more time to explore whether this is right or wrong, because I realize, of course, where you draw these lines is a very complicated question. But my sense is that Facebook, YouTube, Twitter, similar platforms as providers of hosting for users, again, to reach the willing viewers. We're bracketing the question of what to do with comments, which I think is a more complicated question we'll get to a little later. But I think that there's a good argument that they're similar to phone companies and should be treated as common carriers like them, and that is a way of dealing with some of the concerns that Justice Stevens expressed as to corporate expenditures, but as applied, I think even more, are even more strongly applicable to corporate power to dominate the to at least influence seriously political debate by blocking access. Let me just close with one thing. Facebook, to the best I could tell from doing some research, is the 5th wealthiest corporation in the United States. It is owned by owned primarily by one of the wealthiest people in the world. I don't think he's a bad guy. I don't think Facebook is a bad corporation. It may be that some of their blocking decisions are perfectly sensible. Maybe on balance, they're better for society. I don't know. But boy, I think we ought to be kind of worried about having that much power over political debate in the hands of a company like that. So with that, I turn things over to Shaun.
Great, thank you. That was fascinating. Before I respond to that, because it really does spur me to jump into Justice Thomas's recent concurrence. I want to have a couple of points at the outset to frame the issue for us. So we're talking about the First Amendment and deplatforming. First of all, there's a lot of public misconception, and even in the statements from some of our members of Congress about the role of the First Amendment vis-a-vis who it can restrain. We've got to remember the First Amendment constrains government action. And there's a lot of people who want to jump over that first step and say Facebook or Twitter are violating their users' First Amendment rights. That's a big hurdle to get over. And we can talk about whether or not there's a basis to treat them as state actors in the current environment. The second issue, you could think of this almost as a First Amendment issue spotter. Right? You law students really enjoy these long, rambling issue spotting essay questions, I know. So where might the First Amendment come into play as we wrestle with these with the issues that deplatforming raises? So maybe the First Amendment does directly regulate Facebook, Twitter, the other platform members as state actors. If it doesn't, though, what role might the First Amendment play in a challenge to a law that Congress or states might pass to try to regulate the ability of platforms to remove members or remove content? So the first question you have to answer is what they're doing speech? You then have to do speech so that it falls within the First Amendment's protection. Then, if it is the area, and this gets really to what Eugene has been talking about, is the area that these platforms are operating in, is it like these other areas where we've granted some leeway for the state? We recognize some diminished First Amendment protection for the state to regulate the actions of, say, broadcasters or commentarians. And lastly, if you get through that point, is the law, whatever form it might take, is it drawing a content-based distinction on what platforms are able to remove and not remove? So if you simply say the platforms, they cannot remove content because of its political or ideological viewpoint, I think you get into a difficult situation, as opposed to a blanket neutrality rule which says you can't remove anything, which might fare better under First Amendment scrutiny, but might not be that useful as a matter of policy. So let me jump to Justice Thomas's recent concurrence in the Knight First Amendment Institute case. You may know this case. The Second Circuit had an opinion where they said that Twitter, for purposes of, or President Trump's Twitter feed for purposes of the First Amendment, was a public forum, and therefore, when President Trump blocked critics from that Twitter feed, he had violated their First Amendment rights. The Supreme Court dismissed that case as moot. He's no longer in office, and in fact, his Twitter feed is gone. So mootness seemed like the right call there. But Justice Thomas wrote to concur and ruminate about some of the issues that we're talking about now that seem to be on his mind. And so one point he made was this discomfort with the degree to which this concentration of power, this near monopoly of power over speech exists right now in the social media platforms. And so my immediate thought was, like Eugene, Citizens United, and I thought it would be awfully interesting to see the Roberts Court suddenly take a role in pushing back on the extent to which concentrated economic power affected individual liberties. I don't think that's the direction the court's going to go, but it was interesting to see Thomas voice that as a concern in his concurrence. So that's my introductory remarks, and I think we should figure out what we want to talk about from there, because we've got about 15 questions on the table I'm sure we can handle.
Thanks very much, Shaun, for that. And let me just start. Maybe I'll have a brief response, then you have a brief response, and then I'll be happy to turn to the questions. Let me just start by total agreement that that the platforms are not government actors for First Amendment purposes. So nothing that I'm talking about here, it seems to me, suggests that somebody could just sue Facebook saying you violated my First Amendment rights. They're not Congress. That's the first word of the First Amendment. They're not the federal government. They're not a state to which the First Amendment's been applied through the 14th Amendment, or a state actor. It would take a statute to require them, like statute treating them as common carriers, to require them to not discriminate in their, let's say, removal decisions, or just not to remove sites without the owner's permission. That's the question. Imagine that the Congress or a state, in part because of the current political valence of this, may be more likely to be coming from state legislatures, in which some such bills have already been proposed. Imagine Congress or a state says that platforms, say, for example, can't discriminate based on viewpoint in removing sites. So one question that you raise is, what about the platform's own First Amendment rights? Can the platform say, we have a First Amendment right not to be compelled to host things? Like a newspaper has a First Amendment right not to be compelled to publish speech that it doesn't want to. So let me just quickly run through several cases which are the key precedents in this area. So Miami Herald v. Charnilla specifically said newspapers can't be required to publish replies to criticism of candidates. A newspaper can't be treated as a common carrier or as a place of public accommodation or some such. The Harley case said the same thing as to parade organizers, that the St. Patrick's Day parade organizers were ordered by the state government to include a pro-gay rights float that they had excluded. And the court unanimously said that kind of order is unconstitutional because the parade organizer has every right to pick and choose which floats to include in its parade. So you might say from there, well, any property owner, anybody who provides a platform on which others can speak or through which others can speak, has the First Amendment right to exclude whatever it wants to exclude. But that's not the way the courts have ended up handling this. So there's a case called Pruneyard. All of these are Supreme Court cases. A shopping mall may be required to allow leafletters and signature gatherers. Even if the shopping mall owner says, I don't want these people here, I don't agree with their message, or I just don't want other messages that might conflict or kind of distract from my message of jolly shopping fun. Nope. If a state wants to treat shopping malls as essentially a kind of common carrier or public accommodation for people who would come onto the publicly accessible property only and leaflet, it's free to do that without there being a First Amendment defense to that on the part of the property owner. Turner Broadcasting said the same thing about cable system. Cable system, like Spectrum or something like that, I guess Time Warner is what it used to be called, might be required to carry broadcast channels. There was a statute that said if you're a cable operator, you have to include broadcast channels. The cable system said, well, wait a minute, that violates our First Amendment rights to pick and choose what to allow on our property or what to distribute. And the court said, well, it's constitutional for Congress to do that because it doesn't really interfere with your own speech, at least doesn't interfere enough. There's another case, Rumsfeld v. Fair, from about 15 years ago, which said a university may be required to allow onto its property military recruiters. Universities objected to allowing military recruiters because the military at the time had a policy, the don't ask, don't tell policy, which discriminated based on sexual orientation. And they said, we have a First Amendment right not to allow them to speak on our property in our classrooms or in our interview rooms. And the court unanimously said, nope, that doesn't violate universities' First Amendment rights. By the way, the statute there made that a condition of government funding. But the way the court upheld it, it said, we don't care if it's a condition of government funding. Even if the university were by law required on pain of fines or jail for its president to allow military recruiters, that is constitutionally permissible. And the distinction that the court has drawn between that, the last three and the first two, I think is well captured in the explanation it gave in Turner. The programming offered on various channels by a cable network consists of individual unrelated segments that happen to be transmitted together for individual selections by members of the audience. And newspaper's not that. Newspaper, a lot of people read cover to cover. A parade, people watch beginning to end. Likewise, that's that right-hand side of the Twitter feed, of a Twitter page, which says, here's what's trending now. That is, I think, Twitter's own speech. And as I said, I don't think that the government could say Twitter has to promote people's speech in the sense of including it in that list on an equal basis. But when it comes to just a decision as to whether somebody can go to subscribe to a particular Twitter feed or go to a particular Facebook page, I do think that that's a lot closer to Turner, Pruneyard, and Rumsfeld, because those things like a page on Facebook is indeed something that's transmitted for individual selection by members of the audience. Some people go to one, some people go to another, some people go to several more. So that's why I think as a First Amendment matter, if indeed these statutes were enacted, I don't think that they would violate the First Amendment rights of the platform, so long as they're narrowly focused on the platform's hosting function and not the recommendation function.
So Eugene, would you leave that slide up? Because it's really useful as a way to talk about
Absolutely.
the cases. So
Absolutely.
when you go through all these cases, the one factor that really seems to be pushing the court one way or the other, given the case, is a combination of either the editorial control of the platform, the entity, and whether or not the speech at issue that they're required to host would be attributed to the entity bringing the challenge. And those are in some ways two sides of the same coin. In Miami Herald, the newspaper makes these editorial decisions, and therefore we understand the newspaper to be responsible for what it puts out there. And so the question really is, as you lay out this spectrum, where should the platforms fall? One thing to think about is cases where requiring hosting, requiring this content to go forward are to some degree the exception, not the rule, right? It's going to be difficult to overcome the idea that, listen, we have some First Amendment obligation here, First Amendment right here to decide who we put on our platform and who we don't. So can you shoehorn? I mean, it's not, the platforms aren't Rumsfeld versus Fair, right? The platforms, I don't think, are even Pruneyard. Turner is where you're getting close. The platforms are making some decisions about who gets on our network. Now, it may be that the platforms are actually doing less than Turner Broadcasting is, right? Turner Broadcasting wants, yes, there's tons and tons. Now there's thousands of cable channels. Whereas the platforms, they want everybody, right? They just want to engage in some way to keep the content from getting so far out of control that users don't want to come there anymore. But the way that the platforms work now, as opposed to the way they might have worked in at the time that Section 230 was enacted, where you had passive bulletin boards for the most part, the way the platforms work now is, yes, there are hosting activities that they do, but the bulk of what they're doing is curating and amplifying. And so I think the fact that that is such a part of their role because of the economic purpose of the platforms, they're trying to engage us. They're trying to make user engagement more valuable to them through advertising. And so it makes the platforms run as these economic content promotion or content amplification engines, which for me moves them out of Turner Broadcasting and more into the realm of a newspaper, or at least the parade organizer, where I feel like they're on the hook in more ways than a much more passive recipient like universities allowing people to recruit on their campuses. And so that role that they take gives them, I think, a stronger claim to have some First Amendment rights. Now, I have to admit that argument feels a little dirty to me because it's so infused with commerce. And I feel like to jump to a whole separate strain of First Amendment jurisprudence, I feel like the court for decades has been confusing commerce with speech. So if I were allowed to remake all of the doctrine, there'd be a much sharper line, and that might lead to a different outcome in a challenge by one of the platforms to a neutrality law or an across-the-board hosting law. But given where we are, it's difficult to see, at least in my view, the platforms losing the First Amendment challenge, unless the law is really, really bland, like a consumer disclosure law. The platforms, like in the area of data protection, you have to publish terms of service, which provide what your content moderation will be, and you have to follow those terms or you've committed a consumer protection violation. Like, that seems like it wouldn't present nearly as much of a challenge as you must host neutrally. And I think that's the more interesting law to think about. Go ahead.
Shaun, so I appreciate that obviously one can analogize or distinguish all these cases. None of them is squarely on point. But I wonder why we can so casually dismiss Rumsfeld. Let's look at universities. Universities, much more than platforms, are in the first and foremost in the business of promoting their own speech and promoting their own curating decisions, right? The university's choice of speakers for its own speaker series are curating decisions. University's choice of faculty members to teach classes, curating decisions. University's choice of panelists on at conferences, curating decisions. University is 99% its own speech and its own curating decisions, but 1% or maybe 5% if you include some student groups. It does open things up in some measure to other speakers. And it says we also want to be able to curate those speakers. We already exclude certain recruiters. In fact, we exclude recruiters in particular of any sort, military or otherwise, who discriminate based on sexual orientation or race or sex or whatever else. They want to come onto our property, talk to our students in our interview rooms. Our students are upset by this. Our donors are upset by this. We have reasons, both commercial and ideological, to exclude them. Court says no, unanimously says no. You could be required to allow these military recruiters on campus, in part because you're free to dissociate yourself from them. You're free to put up signs saying we don't approve of them. In fact, we encourage you not to go there. That once it is clear that you are required by law to allow the military recruiters, once you educate people about that, then at that point they will no longer associate this speech with you, even though it's on your property, and they will recognize that this is something that's just a third-party speech that you happen to be legally required to host. That strikes me as actually, if anything, a stronger compelled speech claim than platforms claims, again, because universities are so much more places for their own speech. Let's say maybe they're 95% their own speech, whereas platforms are maybe 20 or 30% or 50% if you include platforms' own speech and curating decisions. But one way or another, it seems to me that Rumsfeld, or rather, I'd say the combination of Prunier, Turner, and Rumsfeld make clear that it's not just an exception that property owners could be required to host other people's speech. It's a pretty strong doctrine. Three cases do not, I think, an exceptional rule make. They make a principle, and the principle is that generally speaking, property owners can be required to host material on their property, even if they disapprove of it, so long as it really is likely to be perceived, or likely to be not so much perceived, likely to be consumed as a set of unrelated segments, the way that it is when I go to your page and somebody else's page and somebody else's page, rather than as a newspaper which one reads cover to cover, or as a parade which one watches beginning to end. What do you think about Rumsfeld? Do you think that that's just not at all applicable here?
Here's the tricky part of arguing from Rumsfeld as precedent is you need to, at least in my view, argue with the picture that the court described rather than what is likely to actually happen on the ground. I don't think people truly disassociate universities' decisions, even if they're compelled to allow people to come on campus, from universities, from their own speech. I don't agree that it's so easy, as the court suggests, to say, well, you can just disassociate yourself from those speakers. I think university administrators might take a lot of flack for who comes to interview on campus. Maybe that's driven by my own personal experience in the role of university administrator. But I think that the platforms are in a different situation in terms of their ability to dissociate themselves from the speech that they host. I think people hold platforms very much responsible for the content that appears there. And you can see that in the debate that's happening now about deplatforming. one side believes that they're removing entirely too much speech and the other believes that they're not removing nearly enough speech. But in each case, the platforms are seen as somehow being responsible for taking a role in that speech, even if they put a notice on that says, hey, listen, this doesn't appear to be true, or we fact check this and this is false. So I see platforms different from universities, at least as far as the court described them, and being able to so easily dissociate themselves from the speech at issue.
Well, I appreciate that, although it sounds like you're disagreeing with Rumsfeld here, that the court in Rumsfeld said, rightly or wrongly, that essentially said, you guys need to say you don't that you don't endorse this, and we assume reasonable people will understand that, and if they don't understand it, tough. That's what the court said with regard to universities. I'm not sure why I would say anything different in regard to platforms.
I think the way that it's perceived would be different with platforms. I think the role that people see platforms as having is so much more entwined with the content than the basis for the Rumsfeld decision, right?
Well, but isn't that what the court is essentially getting at there? Which is, look, it's people might assume that something on somebody's property is endorsed by them. Certainly before Pruneyard, I would have assumed that if I go onto a shopping mall and there are leafleters for Clause X, it's because the property owner endorses it or at least accepts it. But once it's legally required for the property owner to host things, then the property owner can explain to the public, don't blame me, I'm just following the law. And we assume most of the public will agree. And the public says, we don't care. We can't stand you. We'll boycott you, even though you're just following the law, which could have equally been done in Rumsfeld. Well, too bad. You can't have kind of this stubborn public insistence on faulting a property owner for merely complying with the law. You can't have that itself be a basis for trumping the law. Again, that's how I read Rumsfeld, and it seems to me hard to see how Rumsfeld could be read differently, as opposed to saying that Rumsfeld got that wrong.
Well, one way to see it as a different case is the role that social media plays in people's lives today. And so very many of us live our lives through these platforms in some measure. And so, both from what I post and in what I consume, it's just, it's so much more central to my experience, to my collective experience, the experience of people that I associate with, that I try to disassociate with. And I think it's less plausible to me to say that, well, platform, all you need to do is say, I don't agree with this, and people won't see that as part of you and your venue, your platform, your service that you're providing to people.
Well, but
I see that I've not persuaded you.
Right. Well, just universities, people, lots of students live on campus. To them, the university, especially if it's one of the universities that's sort of in a small college town or out in the well, I shouldn't say boonies, that's a big city pejorative, out in a rural area. But even like UCLA, which is in the middle of the city, but lots of people live on campus, the university is pretty all-encompassing for them too. But to the extent you do think that social media platforms are an even more important part of people's lives, I would think that would be reason to be more skeptical of their power to decide what is and is not presented to their viewers. The more powerful the platforms are, I think that's not a reason to say, well, you're so powerful, you're so encompassing, you get extra protection because you're so powerful. I mean, it'd be a basic extra restriction.
It's what it is another way, I think, and it's a valid one, to try to go after the platforms, but it's a basis, I think, to treat Rumsfeld versus Fair differently than the case that the platforms would be challenged.
Got it. So yeah, I'm sorry.
No, I was going to say, but I feel like we've exhausted that.
Right, exactly.
And there's lots of interesting stuff to move forward to. One question I had is, as you're looking at the varying laws that are being proposed, it seems to me that a lot of them are blundering directly into content-based distinctions. As opposed to, I mean, my suggestion was a bland law in the nature of disclosure and follow your terms is much more likely to survive. But what are your thoughts on the extent to which, given the current court's approach to content-based distinctions.
Right.
What's the you can't deplatform on the basis of politics or ideology likely to yield?
Right. So again, let's look at a spectrum. One possibility is, let's say a statute says you can't deplatform anybody except pro-terrorist or anti-American or racist speech. That's clearly unconstitutional, I think, because that is viewpoint-based, maybe protection for certain speech, but it's still viewpoint-based protection for that speech. And I don't think the court will have any appetite for that. At the other extreme, let's say they say, platforms are like phone companies. They can't remove material, at least being hosted, for any reason other than perhaps that they are convinced that it is actually illegal, and therefore they may be liable as aiders and abettors or whatever else. I think that would be, at least that wouldn't be viewed as impermissibly content-based. Now, what if they have a rule? And by the way, note, I'm only talking here about regulations of the platform's hosting function. I do think that kind of rule, if it applied to kind of messages people sent or comments, that would be impractical because of spam. That we trust these platforms to shield us at least from certain kind of material, chiefly spam, that will otherwise make it unusable. But as the hosting function, I don't think that's as much of an issue, because if somebody wants to set up some sort of spam page, that doesn't really hurt anybody, because nobody will come and see it. So what if they say the rule is viewpoint neutrality? You can impose content-based restrictions, but not viewpoint-based restrictions. It's interesting. Of course, the line between the two is hard to draw, although it's also a line that courts have concluded can be drawn, because that's actually the First Amendment rule for so-called limited public fora. The analogy I would draw is that some state statutes ban employment discrimination based on employees' political activity, based on sometimes employees' party affiliation. They don't categorically ban all this. By the way, I'm sorry, that's not federal law, of course. Federal law bans discrimination based on race, religion, sex, sexual orientation, various other things, age, disability, but not political activity. But about half the states have such laws that apply either to broader or narrower ranges of political activity. And I'm inclined to say that those are permissible, even if they don't say no, that you can't punish any employee based on speech, but focus only on expression of, let's say, ideological viewpoints. So I'm inclined to say this kind of not complete common carrier rule, but says you can't block things based on viewpoint. I would think that wouldn't be treated as a content-based rule. It's true, it prohibits only discrimination based on viewpoint, but not discrimination based on other content. So for example, there could be a rule that says no vulgarities or something like that. And that it makes it similar to, again, certain First Amendment rules as to limited public fora. But I don't think that the fact that it doesn't protect against all content discrimination makes it itself content discriminatory. That would be my sense, but it's hard to tell. I'll give you one analogy, by the way. So California says shopping malls have to allow all speech on their property, but subject to content neutral restrictions. Massachusetts, as I understand it, in fact, your own state of Massachusetts, I believe says we don't have to allow all speech, but you have to allow signature gathering for initiatives and referenda and maybe candidate measures. Actually, I'm not, well, whatever, signature gathering for whatever signatures Massachusetts law allows. So that's not a complete free speech for everyone. It's only as to particular subject matter initiatives, in part because the court read that into the Massachusetts Constitution, not under the free speech clause, but under its initiative, under its, I think, initiative and referenda clauses. And I don't know of anybody having challenged that as impermissibly content-based. I'm inclined to say courts would be open to that, even though they wouldn't be open to it if they said, well, we protect all petitions, but not racist petitions.
So sticking with the idea of a public accommodations law for internet platforms, I mean, that was another idea that occurred to me when I read Thomas's concurrence, because he points to public accommodations as another way to get at regulating the speech of platforms. And here's what I think: if it's only targeted at one area, right? If it's purely political non-discrimination, it's much more likely to be treated negatively because it is singling out one type of speech, regardless of the viewpoint of that speech. On the other hand, and this is what I thought would be interesting, if folks take the political ball from Thomas and run with it, what about a broad public accommodations law for social media platforms that covers every category that you will find in accommodations law around the country, including political activity? Now, it might bring in categories that proponents of current legislation don't want, which would make for an interesting political debate. But it might solve some of the problem right now, which is nobody agrees on the problem, so it's hard to agree on legislation.
Right. Interesting. So I'm sorry, actually, there's plenty of questions, as you mentioned earlier. So let's just turn to the questions.
Yeah. Could we have some moderating help maybe in picking out questions for us? There's my chat.
So this has been great. This has been fostering a lot of debate and discussion in the chat. So I'm actually going to start with a question from one of our attendees. Can we modify section 230 of the Communications Decency in such a way so they are either platforms or publishers? The determination of mootness seems negated by the chance of repetition.
Well, the mootness had to do with the special weird facts of the Trump case. And just as Thomas used this as an opportunity to talk about these other things. But the other things interesting and important is they are not really closely connected to that. But the other part, so it sounds like, well, at least some people say, and maybe this is what the questioner is getting at, is that platforms should be able to choose. Basically, either they are treated like newspapers, in which case they have every right to include or exclude whatever they dislike, or maybe like bookstores, every right to include or exclude whatever they dislike. But then they're subject to the liability imposed on, let's just say, bookstores, because that's maybe a closer analogy, which is that if bookstore is alerted that a book that it's selling is defamatory, then in that case, it could be held liable if it doesn't take it down. So they can choose editorial discretion coupled with at least some kind of liability, maybe notice and takedown liability, or they can choose common carrier status, like a phone company, which is required to carry everybody. But again, the long-standing pre-Section 230 common law rule was phone companies are not liable because they're mere platforms. They're not actually distributors who exercise discretion. So it's interesting because right now, Section 230 essentially says platforms, you have the traditional discretionary selection function of bookstores, but you have the traditional immunity of phone companies. And, you know, there's nothing unconstitutional about Congress saying, okay, we're going to let you have your cake in a sense and eat it too. That you can, you get both the immunity and the editing discretion. That was Congress's choice. But maybe Congress should make an alternative choice or a different choice, which is to say, you get to choose. You get to either have common carrier status and immunity from libel lawsuits, or you get discretion like a bookstore does, but limited immunity. That, by the way, is what the common law had been seemingly moving to, although we only saw 2 decisions on the subject before Section 230. That's what the court seemed to say. If you edit, then you are not liable, but then you are liable potentially for defamation. And if you don't, then you're not. And Congress didn't like that because it actually wanted to encourage editing. But maybe Congress should step back from that. It's an interesting question. I'm not wild, by the way, about the prospect of bookstore type liability for platforms. I think that would end up chilling way too much speech online, because platforms would get all these takedown demands from especially well-heeled potential plaintiffs, Scientology, or other kind of litigious entities. And whenever they get such a demand, they just take things down and thus over-censor. But one could say that they should pick it, that they should choose which kind of world they want to operate in.
And so, if you think about the problem that Section 230 was trying to address, it was looking at what is the internet, this nascent thing at the time. It was 1996, and the average, I remember the average user spent 30 minutes browsing the web every month. So this was an entirely different world than what it is that we're in now. But the concern was, if you're forced to make this choice, you have an incentive to not regulate, to not moderate at all, which risks turning your platform into a cesspool of just awful content. On the other hand, if you try to fix it, you expose yourself to more liability. So that's what 230 was trying, in some respects, to fix. I'm not a proponent of blowing up 230 and starting over. I feel like, given how fast the technology changes and our use of that technology changes, nibbling at the edges to solve the problems we can agree on is a better policy way to go than erasing it all and saying, boy, I wonder what will happen now with speech hosted on platforms.
I'm not a fan of reducing immunity as well for reasons that I mentioned. I should just stress it. I do think that there are two kinds of cesspool concerns. One is, if a platform really is a full-on complete common carrier, cannot edit at all, then here I have my page. I set up comments on it, and then people start spamming me, people start sending me threats, people start doing all these things. And as a result, this conversation in the comments becomes useless, and the comments feature becomes useless. I think that, yeah, that's a serious concern that would make platforms much less valuable. On the other hand, another cesspool concern is, well, there is this page on this platform that is horribly hateful. It is racist, it is anti-Semitic, it is pro-murder of Americans, it's pro-killing police officers. It's a cesspool, and we need to do something about it. Well, I don't think that that's that much of a problem any more than the fact that the phone company I happen to know serves phone lines to the Ku Klux Klan. I don't like the Ku Klux Klan, but I don't think it makes the phone system a cesspool, but it actually provides that, in part because it doesn't affect me directly, in that I don't have to go and call the KKK number. I don't have to go to the KKK Facebook page. And to the extent it may affect me through kind of it spreads bad ideas, well, I do think that free speech principles ought to protect bad ideas, and maybe even on platforms and not just from the government. So I do think that anything that requires platforms to kind of stop their moderation of comments and such, it would pose very serious problems just to the utility of platforms. On the other hand, if somebody is sending things to willing listeners, then you can't block those. You can debate whether or not that's good for the country. You can debate whether or not that's good for the property rights. But I don't think that would make Facebook unusable if people just happen to be able to post whatever they like, just like they can on the phone company.
That's great. We have another question. Are there real world analogies useful here, or are they misleading in the sense that social media platforms are unlike anything non-digital? To this end, are we so far beyond the veil that past the First Amendment precedent is inapplicable?
Well, so there's an old saying, I forget from whom, every analogy limps. Like, no analogy is perfect. If it were perfect, it wouldn't be an analogy, right? It would be identity. But this is the way our legal system works, right? By analogy, right? Because you could say, if it's nothing like any of that, then we have to start from scratch. Is libel protected online? Well, we have to have a whole new decision because it's not at all analogous. Is incitement protected online? Is it permissible for the Sedition Act of 1798 to be reenacted for online speech? Well, we have to reconsider everything from scratch. Courts don't do that. That's just not the way they operate. Maybe Justice Thomas at times sort of has such a militant view of originalism that he says, I don't much care about precedent in general if I think it conflicts with the original meaning. But even he has to rely in some measure on analogies, partly because there are lots of situations where the original meaning may be unclear and the precedent is all we've got. And on top of that, because the original meaning has to do with other technologies, he has to analogize to the world of 1791 rather than just apply it. So one way or the other, that's the way judges operate. Maybe they shouldn't. Maybe, in fact, just to give an example, imagine that following Jefferson's advice, we had a new constitution drafted every 20 years, and there was a new constitutional convention. Maybe somebody could say, throw all that out. Come up with the rules that we think are right for this meeting. But even there, I think even in the context of legislation and constitution drafting, at least in our system and possibly in any human system, there's constant analogies to, isn't this like what happened before? Go to a faculty meeting sometime or a meeting of any group, and somebody suggests doing something. The first thing people ask is, well, wasn't something like that come up 5 years ago? What do we do then? So whatever as a matter of philosophy ought to be the right approach. I think inevitable the justices are going to look at it for analogies, and certainly the lower court judges are required to look for analogies because that's the way our precedent-based system works, for better or worse.
And I just add that, certainly the court can recognize how different social media is. I mean, if you look to, as it tries to decide whether these cable and newspaper and bookstore decisions are useful as analogies, but look to the change that we saw over the last decade in the Fourth Amendment, where location data suddenly went from, you just understood that if you shared your location or your phone number with a third party, you had no expectation of privacy for Fourth Amendment purposes. Now the court has come to the point where it's just such a part of everyday life that we have to expect some measure of privacy, and the government can't go extract a month's worth of our data from third parties without getting a warrant, or else it violates the Fourth Amendment. So yeah, differences matter, and courts figure out how to negotiate those differences.
Right. So I totally agree with that. Let me just add, though, that when the court did in fact change things in the Fourth Amendment context, look at the opinion. It's chock full of analogies.
Yeah.
However imperfect those analogies are, it's kind of the only game in town. I mean, again, we should always be alive, as Shaun points out and as the questioner pointed out, to the differences. We shouldn't overstate the magnitude of the analogies, but one or another, that's the way briefing works. That's the way opinions work. That's the way I think the mental processes of American lawyers, at least common law trained lawyers, including judges, work.
Great. So we have another question. What measures can be taken legally to counter the effects of big tech social media companies' effects to direct/control the context of forming social constructs?
Wow, that's a huge question.
Isn't that what we've been talking about?
Well, let me go for, but there's so much there. Let me go first by dodging it and saying this, that we're dealing right now with a really complicated thicket of problems, only one of which is, should platforms be able to remove people, right? There is this tremendous accretion of private power. There's a near monopolistic market. So you've got antitrust issues that are getting much more attention right now. There's just unprecedented amounts of data collection, extraction, monetization, use, and manipulation. So there's movements to to change data protection law and and to minimize the way platforms can affect us and how we negotiate our everyday lives. There is just extraordinary political, social, cultural polarization. And boy, I'd love to have a tool to help us bridge those divides, and I don't have one. So we're talking about the deplatforming problem in the middle of lots of other things, progress on any of which might mitigate the deplatforming problem. And so my instinct in a situation like this is to not overreach and make changes that cause these significant First Amendment concerns, and see if we can make progress in these other areas. If the platforms were not rampant engagement engines that were simply extracting our data and selling it in whatever way they can, the platforms might look different too. And that seems a less problematic way to attack the problem, although there are First Amendment challenges that are likely to be raised to that approach as well.
I totally appreciate that. And again, let's just wait and see is often very good advice. And maybe it's quite sound here. I doubt that we're going to see much by way of changes to platforms that diminish platform power, even various privacy related rules. I think that platforms will remain extraordinarily powerful because people want to spend their time online and people want to use them as filters for, not just as filters, as places that they read things. So long as people want that, they're going to provide it. And so long as they have the unregulated power to constrain that, they may very well exercise it. And so I'll just give you one example. This is very, just in some respects, this is hypothetical, but I was thinking about vaccine passports. And I like the idea of vaccine passports, and which is to say that proof of vaccination or other kind of immunity from COVID or future diseases as well can be easily proven, and therefore various businesses and government entities may require that as a condition of going onto a cruise ship or into a movie theater or whatever else. People have some privacy and autonomy related objections. I don't buy that. I actually am a big believer in various kinds of regulations in order to prevent spread of communicable disease, which to me is quite sui generis and justifies some restraints on liberty and privacy. But one of the things that was suggested is, well, why not have it be run by big tech? And I actually think that generally big tech will do a better job of implementing things and providing good customer service in many respects than the government. But one thing that I started kind of wondering about is, what if Google, let's say, is running this, and then somebody wants to use this passport to go to some concert, and Google says, no, sorry, we're just not going to allow this to be used there because that's a white power band, or that is a band that advocates for terrorism, and we're going to deplatform them. Or maybe even we're not going to allow you to go, or we're not going to allow this venue to use this passport for anybody because we know that at some point they have had white power bands there, let's say, or bands that we view as endorsing racist or anti-gay messages, certain kinds of, I think, I'm going to say there was a very prominent Jamaican musician who is faulted for anti-gay messages. Or we're just not going to allow these vaccine passports to be used by a particular person if we know that this person has before used them in order to go to these bad places. 10 years ago, I thought, oh, this is ridiculous. Why even worry about it? Why would any big tech company even care about that? But these days, especially when you have Amazon Web Services blocking and almost killing Parler, the conservative-ish alternative to Twitter, simply because Parler failed to restrict speech on its services, simply because Parler decided to be a little bit more like the phone company, makes me wonder about big tech. They've seen that they have this power. They have internal and external pressures to exercise this power in a way that's compatible with particular ideological beliefs, which is perfectly sensible. Human beings have ideological beliefs, and they may feel almost obligated to exercise their power in a way that promotes them. So I'm worried that, if anything, platforms are going to be exercising that even more. And I don't really see anything other than legislation that's likely to stop them. Now, there's one possible exception, and that is if you do have certain kinds of rules that require platforms to open up their interfaces, so that if I come up with a rival Twitter, I can actually directly access Twitter users. If I come up with a rival Facebook, I can allow people from Facebook to post onto my page and people from my site to post onto Facebook. That kind of interoperability, which incidentally is what we have with phone companies, right? If I have a phone line, I can call people at any phone company. That might itself, without requiring any kind of common carrier legislation, that might itself basically create so much opportunity for competition that we don't have to worry about platforms exercising their power this way. But so long as that's not so long as they have the dominant positions they have, I think we'd agree that if we have a vaccine passport that's run by big tech, we have to have a rule saying big tech can't use that as a means of controlling the ideology of places and people that use the passport. So the question is, should we consider Facebook and Twitter to be comparable in that respect?
So I see that we're almost out of time. I just want to inject one more idea and then walk away without trying to solve it. Trying to legislate to fix any of the problems that we've been talking about is extraordinarily difficult because the platforms aren't a monolith. We think of the big few, right? But Section 230 applies to anyone in the position of hosting content. And the vast majority of remote computing or internet service, not internet service providers, computing service providers, folks who are subject to 230 aren't entities like Facebook and Twitter and Google. And so picking and choosing among them is difficult to do. You can't necessarily limit any of these changes to just the big few. I suppose you could say this law applies only if the owners name rhymes with Zuckerberg or Orsi. But if you do that, then you maybe run into a Minneapolis Star problem where the law said, hey, listen, you can't, we're taxing ink and newsprint only if you sell or use tons of it. Basically, that was treated as a tax on just a couple of newspapers in Minnesota and was struck down for an entirely different reason. So you risk running into that problem as well. It's an awfully difficult area to legislate in.
With that, I entirely agree. And Shaun, thank you so much for participating in this. And thanks to the organizers for organizing it. I very much enjoyed it.
You too. Thanks, everybody.
Thank you so much on behalf of the Federalist Society and UMass Law. We really appreciate both of you guys being here and taking part in this discussion. As you can see in our chat, this really encouraged like a very lively discussion, and that's what the Federalist Society is all about. So thank you guys so much for your time and for coming here and talking with us today.
Thank you.
Take care. Be well.
Thank you for coming, Professor.